The deadlines are coming due as the 2023-24 Supreme Court session is coming to a close with a lot at stake. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are still on the Supreme Court watch. As the session comes to an end, we've got some things that are worth clarifying, some things to look forward to. So to talk us through it today, we have brought back the president of CRPA, that is Chuck Michel. Chuck, thank you for being with us today.
Always a pleasure. Thanks for having me, Kevin.
Absolutely. So I guess, Chuck, to just kind of start this off, you know, we've been on this SCOTUS watch for a little while now. We got a lot of cases that have built up as far as petitions are concerned to see if the Supreme Court would take them. You're talking about individual cases having to do with felon possession of firearms, all the way to some of these cases out of Illinois having to do with sensitive places and magazine bans. We've seen all that pile up. I'm curious, as you see that pile up, what are some of the cases that you believe are going to have the best chance to be taken as far as the ones that are requesting cert by SCOTUS, and which do you think will have the best opportunity to have an impact in the Second Amendment litigation space?
Well, they all have a great opportunity to have an impact. Remember, there's three Illinois so-called assault weapon cases pending cert requests, and there is a New York sensitive places where New York City, or where the state of New York is trying to make every place sensitive, so your CCW is invalid. It's the same game California's been playing. Those are all up for a cert. They've all asked for a review, petition for writ of certiorari, so the Supreme Court would take the case and review them. And we should be hearing from them probably, well, we hear each Monday, we get the rulings that the court made on those requests. So they haven't said anything yet. And so what I hope is that what's happening here is the Rahimi case is there's going to be a decision coming down in that case probably tomorrow, Thursday, if not the following Thursday. And if the Rahimi case or any of these other cases from the Supreme Court actually clarifies what the methodology is, that's the most important thing. Any case, no matter what the underlying topic is, whether it's sensitive places or magazine capacity limitations or semi-auto bans or anything else, including, as in Rahimi, somebody with a restraining order, whether they can be prohibited from possessing firearms. If the methodology is explained in any of those cases, it will help in all of the cases across the country, because courts have been playing games with what Bruen said and twisting the Bruen ruling to uphold gun control laws. So if the court sets the record straight, that will help in every case across the country, and it doesn't matter which case it sets the record straight in. So in a perfect world, the Rahimi case might come down tomorrow that sets the record straight in methodology and how to apply the constitutional analysis. And then on Monday, we get all those cases that are pending get granted cert, then they vacate the lower court decision and they remand the case back down to the lower court saying, you did it wrong, now do it over again based on what we just said in Rahimi. Now, that's probably a reach. I don't know if we're going to get quite that much because Rahimi they could write it very narrowly and not get too deep into methodology. So we just have to wait and see. But I expect we're probably going to see Rahimi tomorrow, and I expect in Rahimi we're going to lose the battle. That is, Mr. Rahimi is going to be deprived of his Second Amendment rights because he's dangerous. But I hope they say that you can't just classify, all felons, nonviolent felons, all cannabis users, all, historically we've condemned Catholics and freed slaves and Native American Indians. Those have all become demonized subclasses of people that the government disarmed. So if you can just slap a label on a group like MAGA supporters or patriots or whatever you want to call them, then you can disarm them, then that becomes a very dangerous precedent because the government can abuse that and has abused it in the past by just condemning, demonizing subclasses of people that they don't politically like. So that's where we're at on that.
Well, let me I guess just clarify something, because I was actually going to ask you a question about this. It kind of sounds like what you're saying. So I guess thinking this out, there are two different things that we could expect from any given Second Amendment lawsuit going to the Supreme Court. One of those things is the same for every single lawsuit, and then the other thing would be different. So if you've got a lawsuit on sensitive places versus a lawsuit on assault weapons, you could have a narrow scope on the sensitive places or on the assault weapons. But what's the same across the board is an expectation or a hope that there will be a clarification of Bruen. What it seems like you're saying is that as far as the clarification of Bruen is concerned from the Supreme Court, there's no right or correct or there's no case that they should take to clarify Bruen. They could do that with any case. Is that correct?
Yes, because the Bruen methodology, remember, it's the first step is a question. Does the conduct or the hardware, the arm, is it covered by the text of the Second Amendment, right to keep and bear arms? And we just submitted a brief, CRPA just submitted a brief in the Kitsap case saying that includes fully automatics. Those are covered by the text of the Second Amendment. Most guns are. And most conduct related to firearms, going to the range, getting your gun fixed, buying a gun, selling a gun, all that stuff should be covered too, marksmanship. And then the second step is it's on the burden of the government to show that there is some kind of historical law that's very similar, analogous to the modern day law that's being challenged, that would show that the founders would have tolerated the modern day law when they wrote the Second Amendment. They contemplated that. But they've twisted this. They've put all kinds of qualifications. Some courts have put all kinds of qualifications on that first step. They say magazines are not arms, so they're not even covered by the Second Amendment. They say, they've just tried to bootstrap a bunch of stuff into that first step so that the government doesn't have to show that there's a historical analog law. If they clarify that, say this first step is not a test, it's just an inquiry. And then they say, and when it comes to historical analogs, they can't just be, some Bowie knife law that was enacted in a few states justifies a modern day ban on all semi-automatic firearms. If they clarify how tight that analogical fit has to be, then that'll be very, very helpful, because the states have been trying to get away with any kind of flimsy little law from the past saying that this justifies the law now. So if they clarify that methodology, that will apply across the board, and we can use that in every case, because it's being misused now by the courts and by the state attorney generals.
Right. Well, I guess one thing that didn't necessarily need that clarification, and the ATF, if you guys have been online watching videos or reading articles, has just been getting roasted by the judicial branch of our government for the last few weeks now. And guys, honestly, curiously, like, let us know in the comments. We don't typically cover a lot of these federal ATF cases simply because they don't necessarily apply to California, since California has already banned a lot of the stuff that they're talking about on the federal level. Leave a comment in the comment section below if you want us to cover a lot of this ATF stuff. But something that we did see come down from the Supreme Court was the Cargill case. That one was in regards to the bump stocks, and I read an article that Stephen Halbrook actually wrote following that decision. Jacob, if you could actually pull this up, I wanted to quote it really quick. The article was called "Second Amendment Roundup: Bump Stocks Are Not Machine Guns." Chuck, what I thought was interesting here were the first couple of points that he made, and I'll read it really quick for you. And dissenting Justice Sotomayor agreed semi-automatic weapons are not machine guns under the statute. Take, for instance, an AR-15 style semi-automatic rifle. To rapidly fire an AR-15, a shooter must rapidly pull the trigger himself. While the term assault rifle is misplaced as applied to a semi-automatic, she correctly referred to the military's standard issue M16 assault rifle as the archetypal modern machine gun. Second, Justice Sotomayor referred to AR-15s as commonly available semi-automatic rifles. Recall that the court in Heller said that firearms in common use are protected by the Second Amendment. So, Chuck, I guess where my curiosity is sprung on this is that whole in common use thing, with Boland arguing for the roster, as well as the Duncan lawsuit here in California arguing against the ban on magazines. The common use has been a pretty typical argument. Here you have a Supreme Court justice who is dissenting from the ruling that we got, generally has not voted in favor of Second Amendment rights at the SCOTUS level, who is essentially making this admission that AR-15s are commonly or in common use, and that they shouldn't be put in the category of automatic machine guns, correct? So what do you make of that, and do you see that having implications in current or future Second Amendment litigation here in California?
Yeah, well, yeah, and in every semi-auto case across the country, particularly the Illinois cases, the game that, first of all, let me clarify something. Common use is not literally the test. The test is there have been historical laws that banned guns that were dangerous and unusual. If a gun nowadays is in common use, it cannot be dangerous and unusual. And by dangerous, that means unusually dangerous. So it can't be unusually dangerous and unusual if it's in common use. And all semi-automatics are. Although some states want to fight about that. They want to claim that they're not in common use. Or if they are in common use, possessed, they're not in common use for self-defense. In other words, the states want to argue that in order for a gun to qualify as a commonly used for self-defense and thus therefore not dangerous and unusual, they actually have to pull the trigger to defend someone, not just have it in your safe in case. They want to argue that you have to pull the trigger. That's complete baloney. But in terms of what Justice Sotomayor said, she did acknowledge that a semi-automatic is not a fully automatic. Doesn't seem like a particularly profound observation, but believe it or not, they're trying to argue. And in Illinois, one of the cases on the semi-auto ban there was that they said they're close enough. They're almost the same as fully automatic, so they can be banned just like fully automatics can. They're trying to blur the line between fully automatic and semi-automatic so that they can ban semi-automatics the way they want to and have heavily regulated fully automatics. So that's a very dangerous ploy. That's why CRPA submitted an amicus brief in the Cargill case, along with Second Amendment Law Center and GOC and some other groups, pointing out that that this was a road they have to be careful about going down. And even now, it's because they're trying to pass a law in DC because the Cargill case knocked out the ATF administrative regulation. And remember, that's what it was. This was not Cargill wasn't a Second Amendment case. It's a scope of the regulatory agency's authority. And every American should be applauding that ruling because it's not just the ATF that abuses its authority and just reinterprets a ruling. For years, ATF said bump stocks were legal. There was in writing specifically about bump stocks that said they're not illegal. Tens of thousands or hundreds of thousands of people bought them based on that. And then they wanted to just change their policy and turn all these people into felons at the stroke of a pen. That's not the kind of thing that a regulatory agency should be allowed to get away with. And Justice Sotomayor saying, if it walks like a duck and quacks like a duck, I call it a duck. Well, no, you can't do that in statutory interpretation because you have to read the literal law. What does the law say? If we're just going to make up and expand the law and say, well, it looks like a machine gun based on how it fired. Well, no, it's a single pull of the trigger every time you have to fire a semi-automatic, even with a bump stock. The bump stock just makes your finger go faster. So, but if you can just twist any law and say, well, it looks like a duck, so I'm going to make it illegal, and you go to prison because you read the law specifically what the legislature told you was illegal, and then some judge says, well, close enough for government work. It's dangerous, and not just again for the ATF. So it was good that they reined that in. That's the administrative state that criminalizes people that they don't like politically, and that's exactly what the ATF had done there.
And certainly something I'm sure is going to be referenced to in future litigation here in California and referenced going forward here. Chuck, I guess just to put a bow on this, I got a procedural question for you. And I'm also curious of your final thoughts, but the 23-24 session for the Supreme Court is coming to an end. They have been holding conferences on Thursday to produce an order list for Mondays over the throughout the session. Tomorrow being Thursday, they'll produce an order list that we will see on June 24th, this coming Monday, of cases, whether they deny them, they grant them cert. I'm just sort of curious. What are you looking forward to? What are you hoping is one thing, or what are your expectations to see any opinions come down, any cases taken up? What is your view going forward? And also, I'm sort of curious, how does the Supreme Court work off session? Will we continue to see opinions even though they're out of session?
They can extend. They won't have oral arguments, so they won't be in session in that sense, but they can extend their session to continue to issue rulings if they don't have them all finished. And they've still got like 40 rulings to hand down, so they're backed up. So they could do that. My hope is tomorrow we see Rahimi, and it tells the lower courts, you've been getting it wrong, do it right. Here's how you got to do it. And then Monday we get an order list that GVR, grant, vacate, remand, the Second Amendment cases that are up for review, because they don't have to hear them because they've clarified things in Rahimi, so they just send them back down to the lower court. Now, if Rahimi doesn't go that far and doesn't clarify those things enough, they might grant cert in one or more of those cases on Monday, or it could all be slid over and pushed over another week. So, but in my perfect world, Rahimi comes down, clarifies things, makes it crystal clear what the test is, how it's to be applied, and then they take all those cases that are before them, asking for review from the Supreme Court. They take them all, they vacate, they wipe out the lower court ruling and say, do it over again, because now we just told you how to do it right. That would be fantastic. Because remember, we have all kinds of cases percolating through the Ninth Circuit. Duncan has been argued en banc. We're waiting for a decision there. I suspect Duncan is the Ninth Circuit is waiting to issue a number of rulings until they see what happens with Rahimi and with the other cases that the Supreme Court's going to take. So there's a lot at stake, and I'm sure that the Supreme Court justices that believe in the Second Amendment know it. So we'll have to see how far they're willing to go to straighten out the lower courts.
Well, there certainly is a lot at stake, a lot to follow along with, and deadlines are coming due. So we are certainly dedicated, and we are going to be covering every single second of this as far as the analysis and the implications for these lawsuits to come down with these opinions. Chuck, I want to thank you for coming on. I assume I will be seeing you shortly as the deadline for some of these cases come down, but I do want to thank you for coming on. I know you're a busy guy.
Always a pleasure, guys. Hey, folks, we give great rates to the CRPA. Our lawyers give us good breaks, but it still costs a lot of money to litigate these cases. So if you can help support the CRPA with a donation or by joining or getting your friend to join, we'd appreciate it.
Absolutely. And guys, if you like videos and you like this sort of content, please be sure to also like, share, and subscribe to these videos. Hit that little notification bell so that as these lawsuits drop, as these videos come out, you are notified immediately and can get that information and pass it along. Thanks again, guys. We'll see you on the next one.